Well, we find it's very common, and that's actually the second thing on my list of 5 common mistakes first offenders make in assault and battery cases. And the reason that's so important is, number one, the prosecutor's been to law school. Even if he or she has never tried a case in their entire life and it's their first day on the job, they know about case law. And their boss knows that everybody's going to go to the internet and research the case. So the internet is filled with statutes and rules of procedure, but it's missing the most important element, that third component, which is case law. Case law is when an appeals court has decided whether or not a particular set of facts means that someone has broken the law or is justified for a jury instruction, or that evidence needs to be excluded or allowed in. Case law is critical. And when someone self-represents, they don't even know how to get full and complete discovery. At best, they get a bare bones police report. Then when they go to the internet, they don't know what to do with it. And then finally, if they self-represent, that's when courthouse surprise happens. And courthouse surprise is an absolute epidemic, particularly in assault and battery cases. In the domestic variant, it's particularly dangerous because I have people contact me on a regular basis who will say something like, I was told by the prosecutor in court on a break that if I took this deal that I would have adjudication withheld. I would not have a conviction. Now I find out I can't own a firearm, I can't go hunting, I can't join the military or stay in to the military or some other protected class where domestics are excluded. And the reason is, under state law, adjudication withheld means literally someone has not been convicted. However, there are other state laws, and there's a federal statute known as the Lautenberg Act, which says even if adjudication is withheld on a domestic, someone still has domestic violence criminal history, and they cannot own a firearm, they can't work in certain capacities and professions, etc. So self-representation can blow up in your face even if you think you've got a good deal, and I'll have more on this later on. But when people get courthouse surprise, such as what I just described, or an unexpected jail term of 10, 20, or 30 days, that's the worst variant of courthouse surprise. And quite often people don't find this out until they're in front of the podium. Overconfidence is the #1 problem that people have going into criminal cases. They've watched a lot of television and movies, so they think they know a lot about the justice system. They also, in many cases, think they're guilty, so gosh, why spend money on a legal fee? Well, the reason you invest in legal services is so you don't experience courthouse surprise, and so overconfidence is not used against you. Just today, another time out of more than I could possibly count, I was speaking to someone on the phone, and they basically said, well, I don't really think I need a lawyer. I can handle this on my own. The other party has gone down to the prosecutor's office and they don't want to prosecute, and they are going to drop charges. Surprise. Only the state of Florida can formally prosecute. Only the state of Florida can formally dismiss charges. So when people are overconfident, they often try and handle their cases on their own, only to find out it can blow up in their face rather explosively. And perhaps the best example of that I know, let me pull my notes up real quickly, is the combination of my friend said, the internet said, fear of the legal fee, and then finally someone wanders into the courtroom and they're going to handle their case on their own because the complaining witness does not want to prosecute. That's a classic example. Well, on a break, they meet with a prosecutor. You see, often people think their first court date is a trial. It's not. It's only formal charging. When someone gets out of jail, even if they've seen a judge on a video camera, which is commonly how first appearance is done, their next legal proceeding is what's known as arraignment. Now, some counties call this plea day. That's technically inaccurate. Doesn't really matter. It's formal charging. But people will go to court thinking it's a trial, thinking they've got a lock, self-representing, overconfident. They'll meet with the prosecutor, And then when they meet with the prosecutor, they'll say, look, I'm not going to take this, I'm not going to take that. And the prosecutor will try and sell them a probation deal in this example. And then finally, the prosecutor says, okay, look, I'm not going to spend all day talking with you. It's take it or leave it. Here's my best deal. You can get a diversion program. Let's compare a diversion program on one hand with a negotiated dismissal on the other hand. The typical negotiated dismissal I have in, say, a battery that's a domestic would be stay out of trouble for 90 days, $303 in fines, costs, and fees. Oh, and by the way, as soon as you pay the $303, the charges will be dismissed. We have an agreement by written contract where the deferment will end upon payment. So somebody can literally sign the deferred prosecution contract on day number one and go down to the courthouse, pay the fees, and then the following day or so, charges are officially dismissed. Now, let's compare that to a diversion program, because I've talked about this for many years, but when I sat down to write this stuff out for an article I'm writing, it shocked even me. And I've done this for over 20 years. So let's actually compare that negotiated dismissal with a diversion program. See, this is why the prosecutor wants an overconfident defendant wandering into court representing themselves, is because this really good deal is going to have the following conditions. Number one, you'll have to enter a plea of no contest. Prosecution will be deferred for an entire year. Now, during that period of time, if everything is completed, the plea agreement is withdrawn and charges will be dismissed. But notice a key difference. Right away, we're talking about a few days versus a year. But there's more. There will be a monthly report to a probation officer, and each and every monthly report is going to cost $50 plus a 4% surcharge. So that's $52 a month. So right away, we're looking at $624 over the course of a year. That's more than twice what a negotiated dismissal will normally cost, at least the ones I handle. Now, in addition to that, there will be domestic violence counseling every single week for approximately 6 months, okay? It's going to be a long period of time, and that counseling is going to cost $700 to $1,000, depending. There will also be a cost of prosecution that will be $50 to $100. Most diversion programs have a very strict requirement of no alcohol at all, not a drop for a year. Plus, you have to pay to be randomly breath tested. There you are, living your life, doing your own thing. Hey, stop what you're doing right now. Come on down, take a breath test. Oh, and if you don't, you get kicked out of the diversion program. You proceed directly to sentencing, and the judge can sentence you up to a year because you've already entered a plea of no contest. So it's a very rigged system, to say the very least. In addition to no alcohol, there is regular random drug testing. And God forbid you pop positive on either one of these, and you have to pay for that drug testing separately as well. Now, this is going to run over the course of a year, from what I've researched, $100 to $300, but don't kid yourself. It's usually closer to $300 than it is $100. And what about court costs? $662. How do I know that exact number? I just had a case where that was a plea offer that we rejected yesterday. So this is the reality. And any violation of this, really good diversion program means, boom, free room and board, no bond, sentencing up to a year. So this is the realistic difference between a negotiated dismissal negotiated by your private lawyer and a diversion program that the state attorney pretends that they're reluctantly giving you. The reason they're doing that is because they're setting you up to fail. Now, why would they do this? Why would a prosecutor who sounds so sincere in the courtroom do something like this? And it's called politics. the state attorney in 20 different circuits across Florida is an elected politician. They run by party preference, which means in an area that's dominated by Democrats, you're going to have a Democrat running for prosecutor. In an area that's dominated by Republicans, you're going to have a Republican running for prosecutor. And in an area that's pretty close, there's going to be some very careful judgment calls made and decisions and things like that, because crime and politics are intertwined very tightly. And no prosecutor runs on a platform of let's be smart about the problem of crime. Instead, they run on the tried and true formula of scare people and, of course, be tough on crime. What we need instead is a smarter way to do things, and what I propose when people are charged with an assault or a battery charge, whether it's domestic or non-domestic, is do the smartest thing possible, which is treat it like you would a heart attack or brain cancer. Get the very best certified expert that you can, who will deliver you the best service possible, and that way you have the greatest odds and likelihood of having a successful outcome, as opposed to paying all that money and spending all that time for an entire year with, what feels like a sword hanging over your head, ready to just cut your life apart. So that's my thoughts on assault and battery at this juncture.
For a free phone consultation, contact Attorney Stephen Cobb in Florida at 850-466-1522 or visit his website at www.cobblawfirm.com.